Welcome to Future Consumer ADR, a podcast where we discuss what's happening and what's next in consumer and mass claims resolution. Hear from experts in their fields on the latest trends and innovations in consumer and mass arbitration, litigation, and beyond. My name is Adam Shoneck, host of the podcast. I am Vice President of Business Development for the American Arbitration Association. I've been with the AAA for 16 years, nearly all of which has been in the consumer space. Today, I'm joined by Jennifer Lupo, an expert AAA arbitrator who has arbitrated numerous consumer and mass arbitration cases. And our topic is the AAA's new consumer arbitration rules. Jennifer, welcome. Could you tell us a little bit about your expertise and background?
Thanks for having me, Adam. I am an arbitrator and mediator seated in New York. I have been a neutral since 2004, an arbitrator since 12. I am a Higginbotham Fellow of the Association in 2018, and I joined the AAA Commercial, Consumer, and Employment Panels in 2019. I have handled numerous consumer matters, including mass arbitrations, as both the merits arbitrator as well as the process arbitrator.
Having done so many cases under the previous rules, so we released new consumer rules last year in May, and you've done cases under both now. What's your overall impression of the new rules?
Very favorable. The association has really taken a really hard look at what trends and what changes were coming to bear on arbitration in the consumer space, and also recognizing that there was a growth in the manner in which folks wanted to do disclosure. They wanted to do multiple day hearings. They wanted to do a variety of things that were not necessarily contemplated by the preceding sets of rules. And the association really took a good look and said, okay, I'm going to meet the consumer, their counsel, and the arbitrators where they need to be met.
Okay. And one of those changes was that the new rules call for virtual hearings as the default, but either party can still ask the arbitrator for an in-person hearing. What would you consider important factors in granting an in-person hearing?
I think there are two. One is a pro se litigant. So when you have a pro se claimant or a pro se respondent, it's important to have them in a room. They are typically not as adept at the utilization of a video conferencing platform, and it would be a remiss on the part of an arbitrator, in my opinion, to not take into account the negative effect that might have on a litigant in terms of their ability to have justice served.
Sure. Part of the reason I could share that we went to virtual hearings was that for many people, being able to do the hearing from your house, or wherever you are is a great convenience and allows extra access to justice. But it's sometimes you need that in-person hearing so they can really fully vet their case.
Another area, Adam, where you would also might consider having an in-person versus virtual hearing is if you have interpreters. That is a complicated area of managing interpreters virtually. It's not impossible. Clearly, if you are skilled at the utilization of Teams or Zoom or WebEx or any of the video conferencing platforms, you can figure out how to manage having an interpreter as well. But it's just one of those areas where it's a little bit more complicated. And if everybody's in the same city, and it's not going to be a hardship having an in-person might be best.
Got it. One of the other changes we made was to discovery and the scope that the arbitrator is specifically allowed to authorize. Um, do you feel significantly different in handling discovery disputes under the new rules versus the old rules?
I do. We were pretty hamstrung as arbitrators under the old rules in regard of what our authority was when we were met with requests for disclosures that exceeded, I think it was charts and graphs and a couple of other things that were in the old rules that folks had to just automatically disclose. And at this point in time, I think what it does in the new rules is it gives the arbitrator the opportunity to work with counsel and the parties to really suss out what type of information is necessary to bring the case to a resolution in an efficient way. And sometimes that is depositions. Depends on the type of case. Sometimes that is interrogatories. Sometimes it's a combination of interrogatories, other types of disclosures, and a deposition. But it gives the arbitrator some leeway to work with counsel and the parties in ways that we weren't able to before.
And that's really interesting because the old rules talked about arbitrators had authority to order anything that was necessary for a full and fair hearing. But we heard from a lot of arbitrators like yourself that it still wasn't expansive enough, that, that it didn't grant enough authority where it was needed. So obviously that was a reason we felt compelled to change that. One of the other things we added was a new mediation process. We'd never had consumer mediation rules before, so we now have bespoke consumer mediation procedures. What are your thoughts on those and whether parties will actually use those?
So I've always asked, even when we didn't have a rule on mediation, I would ask folks if they had mediated and whether they would consider mediation, because we've always had a mediation wing at AAA. So that was one issue. And also that I would address in my original hearing. One of the things that I think is it's early days is to determine whether or not folks understand. When you have pro se parties, they don't understand what mediation is. Some places in this country, there isn't a depth of mediation on a regular basis, whether it's court annexed or what have you. So folks aren't really skilled in mediation, so they may feel trepidatious. And one of the things that I myself always am weighing is, am I, with the authority of being an arbitrator, I have to be cautious in not making the parties feel that I am requiring them to mediate. So I do address mediation, and I would say it is infrequent at this point, but again, it is early days that either folks have mediated and hit an impasse, and then there was a step clause that brought them to arbitration. That's usually unusual in the clauses that we see in consumer, but I do think that folks will maybe start to warm up to the notion that this is a more efficient, maybe for certain types of cases, to get a resolution.
Sure. And we have seen some adoption there, and we tried to make the costs very low, $25 to the consumer party, so that people would engage in it, and we are seeing some use. So that's been really encouraging.
That's great to hear.
Are parties doing anything different in response to the new rules?
I would say yes. I see much more expansive discovery requests.
Okay.
you know, when you in one-off consumers, it's still kind of a more traditional approach where we actually discuss what do you need, what do you want, what have you. But in mass, now that we have the new consumer rules, I do see that either through the utilization of the process arbitrator, there is a significant amount of discovery that is requested and required, which is then pushing out hearings, by a year to 18 months. So I do see that. And I do also see more discovery disputes. I personally have 3 pending right now. And, that's just the nature of the beast when you have folks that have been granted a right now to have more information, but it's not necessarily clear how that is going to play out because everybody has to work together to create and craft what the process is going to be for this particular arbitration. And X wants X and Y wants Y and doesn't think that X should have X and Y should have Y, and rinse and repeat.
Got it. Okay. Well, I think that's sort of an obvious response from parties, to the changes in the rules, but at the same time, managing the fairness of the process is something we're highly concerned with, obviously, and making sure it's a good process for everyone. So, in consumer arbitration and in employment arbitration as well, you're going to have some of those longer timelines in order to make sure it's a fair process.
And that's fine by me, just as long as it's long for a good reason. Like that, I have no problem with it. I don't see anyone misusing disclosures or any other aspect of of the arbitration process, whether it's in mass or in one-off arbs. I don't see that. I haven't had that experience, and I'm thankful for that.
Good. Glad to hear that. One of the other changes we made was we took this from the commercial rules. We allowed the arbitrator to clarify an award. So there's modification of the award, which is for typographical, clerical type errors, but then there's clarification of the award. And an arbitrator can do that on their own initiative as well. What might be a situation where you would feel that you would need to clarify an award?
Mathematical errors. So a mathematical error in an award is one area. And a second area would be is if I was doing it on my own initiative, is if not that I forgot something, but that I don't feel that I was as clear as I can be. Because when you're writing that award for the party who is not prevailing. So I want to make sure that party understands how much time and effort went into the explanation to them why they didn't prevail. So, we're not infallible. Judges aren't infallible. Sure. So, and every now and again, you'll say, "Ooh, I really wish I could," but you're functus officio. Right. So I'm happy to see that opportunity in the consumer rules.
Excellent. Well, that's all the question I had. So I really appreciate you joining the podcast today and for all your insights and, of course, for your continued work as one of our expert arbitrators. So thank you so much. And we'll talk again soon.
Thanks so much for having me.